Okay, so now we will look at national treatment obligation, which is NT obligation. And this is the second principle of non-discrimination. The first principle we look at is most favored nation, which basically prohibits discrimination amongst countries. And national treatment is discrimination or a principle that prohibits discrimination against countries, against imported goods. Right. So let's start from it has three main subparagraphs. So Article 3 is all about national treatment, and Article 3 has three main subparagraphs. Article 3.1, which is the umbrella provision, pretty much talking about the spirit and the meaning of national treatment. So it doesn't contain any legal obligation as such. So if you're filing a case and if if you're accusing a country of violating Article 3, you cannot file it in Article 3.1 because it is the umbrella provision containing the essence and spirit of the provision. It reads as follows. Don't be discouraged with the reading because, as you know, we're going to break it down in simple words. The contracting parties, which are the WTO members, recognize that internal taxes and other internal charges and laws, regulations, and requirements affecting the internal sale, offering for sale, purchase, transportation, distribution, or use of products, and internal quantitative restrictions requiring the mixture. So, in short, WTO members are saying that they recognize that internal tax or any other internal charge, law, or measure, which is not a border tax or a border measure, but something internal, once the good has crossed the border, should not be applied to imported or domestic products so as to afford protection to domestic production. So all they are saying here is that WTO members should not impose any internal taxation or any internal measure or law that discriminates between like domestic and like imported product. If I have produced, for example, if this pen is made and manufactured in Mexico, and I'm also importing similar pens from China, then I have to treat domestically this pen as well as the pen I'm importing from China equally. I cannot say that I'm exempting sales tax or excise duty from the sale of this pen, but I'm imposing 10% on the sale of foreign pens or imported pens. So this is what it is saying. Because some countries sometimes they want to protect their domestic industry. They want to protect their domestic manufacturing. Because if they protect these domestic industries, these industries can grow and they can help the economy of the country, especially for developing countries. Protecting some crucial, strategic, economically important industries are very important for the economy and for the subsistence of the people and also for self-reliance. Now we are living in a pandemic era where you have seen how important it is for a country to be self-reliant, to be self-dependent, and not to be reliant on other countries for food or for basic essentials or for pharmaceutical products or drugs or medicines. So countries basically try to gain self-reliance by giving protection to their industries. And this article is prohibiting that. Now you would ask me why this doesn't seem fair. Well, there are exceptions. Don't forget about that. We'll look at the exceptions in due course, but there are exceptions that would allow countries to violate Article 3 and the justification of various excuses or various reasons we will have a look at in due course. So Article 3.1, a very general measure. It only talks about the essence of Article 3.2 and Article 3.4, the two most important paragraphs of Article 3 of national treatment, where you will find cause of actions, where you'll find substantive obligations, which you would invoke your action in. So let's go ahead. And the final thing here is that national treatment, as in the case of most favored nation, could be de jure as well as de facto discrimination. We'll see what that is. Okay, so let's have a look at this example. on understanding what de jure discrimination of national treatment could be. So, Korea beef is a famous litigation from a couple of years ago. In this case, basically, Korea came up with a dual retail distribution system where there was a measure in Korea that said that domestic beef, so the beef processed and produced in Korea, is allowed to be sold anywhere in any supermarket, grocery shops. But then imported beef can only be sold in specialized stores, or if they are to be sold in supermarkets, they have to be placed in a separate section of the supermarket. They cannot be sold together with domestic beef. This became a problem for US because US at that point and still used to export beef to Korea. And US alleged that this is a clear violation of Article 3.4. It is a violation because it is granting less favorable treatment to imported beef. And the appellate body decided that this is a de jure discrimination, but it does not violate Article 3 because they are only treating domestic and imported beef in a different manner. They are not discriminating between imported and domestic beef. And I do not agree with this decision. I think this goes against logic because if you are a consumer and you go to a supermarket, would you take the effort of going to a specialized section or a specialized store to buy imported beef? Or you would rather just be swifting around the corridors and you would pick up any beef you would see, and you would commonly find domestic beef in common sections of supermarkets and grocery outlets. So I see this measure clearly favoring domestic beef and not favoring imported beef, but the decision of the court was not the same. And then you see a de facto example of discrimination. This is another famous case called Japan alcoholic beverages. So what happens in this case is that Japan imposes higher taxes on internal taxes, domestic taxes, on vodka and other white spirits, and it imposed lower taxes on shochu, domestic as well as imported. So the measure said that lower taxes for shochu, which is a traditional Japanese white spirit, and higher internal taxes for vodka and other white spirits, domestic as well as imported. But in reality, shochu was only domestic. They did not import any shochu, but all the vodka and other white spirits they had were mostly imported. So you see what de facto discrimination is. The measure did not discriminate on the basis of origin, actually on the face of it in a written manner. However, the impact of the application of this measure was discriminatory against foreign alcohol, foreign spirits in Japan. So this is a classic example of de facto discrimination. And the appellate body ruled that this is a violation of national treatment. Now we are going to look at and we are going to understand Article 3.2, which is very important for the purposes of this course. So Article 3.2 is divided in two parts, first sentence and second sentence. The whole article contains two sentences. So each sentence basically contains a separate legal obligation, and each sentence has different elements that we have to satisfy to argue violation of that legal provision. So we will look at first sentence of Article 3.2, and then we will look at the second sentence of Article 3.2 and their respective elements that you need to satisfy to argue a case under either of these. Remember, they are two separate legal obligations. They are known as Article 3.2 first sentence or Article 3.2 second. So if you're filing a case in Article 3.2, you have to identify whether you are invoking Article 3.2 first sentence or Article 3.2 second sentence. Right, so let's look at Article 3.2 first sentence. It reads as follows. The products of the territory of any contracting party imported into the territory of any other contracting party shall not be subject directly or indirectly to internal taxes. So remember, national treatment is focused on internal taxes, internal measures, not border taxes, not border measures, or other internal charges of any kind. So it may not be a tax, it may just be a financial charge or a distribution charge or a licensing charge or an inspection fees, could also amount to an internal charge of any kind in excess of those applied directly or indirectly to like domestic products. So you cannot impose in internal taxes or internal charges on like foreign products which are in excess of the charges you are charging or you're imposing on like domestic products. Okay, indirectly or directly. So it widens up the scope of the first sentence. So if you break this down, you end up with three elements, and you have to satisfy all three elements together one by one to prove a case of violation of Article 3.2 first sentence. Here are the elements. Number one, you have to answer whether the imported and domestic products are like products. And Spain unroasted coffee case that we saw a while ago was the first case that gave us the guiding factors to determine likeness of products. However, the case has been, or the case law on this has developed quite a lot. So now we have other cases and other WTO jurisprudence that create and that have identified four guiding factors to determine likeness of products. We'll see that in a while. So the first element is very similar to what we had in the most favored nation. Moving on, second element, whether the imported products are taxed in excess of domestic products. So you have to calculate the difference between internal charges or taxes imposed on domestic and foreign. If foreign are taxed in excess of domestic products, then that amounts to a satisfaction of element 2. So if you're imposing 10% of sales tax on domestic like products, but you're imposing 11% or just 10.1% of sales tax on foreign like product or imported like product, that amounts to satisfaction of element 2 because it is in excess of. Anything, even a minor difference, would satisfy element 2. And third, whether the measure at issue is an internal tax or charge. So you have to see whether the tax or charge that the country is imposing is internal, domestic. It should not be a border charge or a border tax. For example, a custom duty or any kind of border tax. It must be internal in nature. So this provision focuses on prohibiting discrimination once a good has entered the market and crossed the border. Most favored nation focuses on prohibiting discrimination at the border. That's the difference, right? So we've already looked at this case. Lower tax, internal tax imposed on domestic and imported shochu, which is a traditional Japanese drink, was the same. So they said whether it's domestic or imported, it's the same. In practice, it's all domestic. The higher tax imposed on imported and domestic vodka was the same. Most of the vodka is imported. in practice. Identical products, therefore taxed identically, was the argument given by Japan. So the key question for the court to decide here was whether shochu and vodka should be treated as like products. If they were alike, vodka cannot be taxed more than shochu, otherwise it would be a violation of Article 3.2 first sentence obligation. So the test they applied was, and this is where they developed the test, in place of three guiding factors. This case or this decision gave us four guiding factors. They looked at the properties or the nature of the product. They looked at the end use in a given market. How is the product used in a given market? And the new element they added was taste and habits of consumers. So they also looked at the habits and consumer preferences regarding these two like products. Of course, the fourth one remains the same, which is how other countries charge tariff on these products. Do other countries charge tariffs in different ways? If not, then that could be a strong guiding factor to decide that they are like products. So there are four guiding elements now. And to determine likeness or assess likeness, whether for Article 1 or Article 3, we should use this case. And we should use these four guiding factors. Product's property, nature and quality, end use of the product in a given market, taste and habits and consumer preferences, and tariff classification by other countries. So the court in this case decided that they are like products, they look alike, they taste similar, the end use is the same, they're used by consumption as alcohol, and the consumer preference is the same. If they go to the market, they don't find shochu, they can buy vodka and satisfy their thirst for alcohol. And the other countries classify them as like products in their tariff regimes, and therefore they are like products. Now, another very interesting case between Mexico and US. So, in this case, Mexico had a measure, a regulation where it used to impose lower distribution tax and beverage tax on cane sugar and a much higher beverage and distribution tax on any other use of sweetener or sugar. So I'll say that again. I think I did not explain it well. So US in this case filed a complaint against certain tax measures imposed by Mexico on soft drinks and other beverages. So Mexico was imposing 20% beverage tax and distribution tax on soft drinks and non-alcoholic beverages that were made using any sweetener other than cane sugar. If a beverage, a non-alcoholic beverage, is made using cane sugar, it did not have to pay 20% of the beverage and distribution tax. Cane sugar mostly was produced in Mexico. So it was trying to benefit that industry clearly. So the issue or the question for the court here was to determine whether beet sugar and cane sugar are like products within the meaning of Article 3.2 first sentence. And they applied the same test of likeness. Products, properties, nature, and quality, end use of the product in a given market, taste and habits of consumers, and tariff classification. And they found this. They said, oh, they have similar features. They look the same, they have similar features, they're both sweeteners, and their end use is the same. They're both used to sweeten the drinks. And the taste and habits of consumers. Have you ever checked the kind of sweetener used in a non-alcoholic beverage before consuming it? Not really. So the consumers don't care whether you use beet sugar or cane sugar. So if you look at all these factors together, the decision would be that they are like products, and therefore Mexico's measure discriminating between the two amounts to a violation of National Treatment Article 3. So that was Article 3.2 first sentence obligation. Now let's look at Article 3.2 second sentence obligation. Okay, it reads as follows. Moreover, no member, no WTO member, shall otherwise apply internal taxes or other internal charges. So far it's the same. To imported or domestic products in a manner contrary to the principles set forth in para 1. So that brings us to para 1, Article 3.1. I cannot pause it here and share my screen, other screen, otherwise it will disrupt the whole process of recording. So I've copied and pasted the content here. So it takes us back to Article 3.1. And Article 3.1 said that you cannot discriminate with the intention of affording protection to your domestic product. So that one element is being imported into Article 3.2 second sentence from Article 3.1. And para 1 has an asterisk. So that asterisk takes us to the footnote of Article 3.1. And the footnote reads as follows. Where competition was involved between, on one hand, the tax products, and on the other hand, a directly competitive or substitutable product which was not similarly taxed. So what you see in Article 3.2 second sentence obligation is that it doesn't use the word or expression like products. You don't need products to be like to satisfy the obligation here. If you break these different parts of legal provisions down, you end up with 4 essential elements that you have to satisfy to argue violation of Article 3.2 second sentence. But remember, to understand Article 3.2 second sentence, you have to read Article 3.2 second sentence in conjunction with Article 3.1 together with the footnote to Article 3.1, which I've copied and pasted here for you. So the first essential element that you have to prove to satisfy the obligation under Article 3.2 second sentence is whether domestic and imported products are directly competitive or substitutable products. So here, they don't need the products to be like. You don't have to apply the likeness test. The products must be directly competitive or substitutable products. Now, how do we differentiate this expression from the likeness of products? We will see in a while. We'll see on the next slide. The second element is that the imported directly competitive or substitutable product must be subject to dissimilar tax. So the tax imposed on imported and domestic competitive or substitutable products should be dissimilar. If you remember, in the previous obligation of Article 3.2 first sentence, the second requirement was tax in excess of, which would catch even a minute difference between the tax you are charging or you're imposing on domestic products and imported products. But here the expression used is dissimilar taxation. It would ignore de minimis. So if there is a very minute marginal difference in taxation on imported and domestic, it would not come under the ambit of Article 3.2 second sentence. The dissimilar taxation has to be more than de minimis, right? Moving on, third element is that it must be an internal charge or an internal tax. It's the same as the previous obligation. And fourth, that comes from Article 3.1 is so as to afford protection to domestic production. So it should not be aimed at or it should not, the measure should not have the intention of giving protection to the domestic industry, to the domestic production at the cost of discriminating against foreign production or foreign products. Now, how do you figure out the intention? Intention can be quite subjective. So, how do you know whether a measure has been imposed with the intention of protecting domestic industry or not? We will see in a while. So, these are the four elements that you must satisfy to argue that a measure or a law or a tax amounts to violation of Article 3.2, second sentence. You have to satisfy all of them one by one in light of the facts. Now, once again, just to be sure that we are on the same page and there is no confusion, Article 3.2 has two obligations, sentence 1 and sentence 2. Sentence 1 requires the products to be like. Sentence 2 requires the products to be competitive and substitutable. So you should try to understand the difference between like and competitive and substitutable products as this. So the relationship is linear. All like products can be substitutable, but not all substitutable products are like products. So the concept of likeness is construed in a very narrow manner. A product is like when it is very similar to the other product. The concept is very narrow. And the competitive or substitutable product concept is construed in a broad manner. In other words, like products must be perfectly substitutable. However, competitive or substitutable products must be substitutable, but they may not be perfectly substitutable. They could be imperfectly substitutable. As long as these two products can be used interchangeably and they can provide different ways of satisfying the same need or the same taste, they can be considered as competitive or substitutable products. So let me ask you this question again. If you go to a grocery shop to buy a bottle of wine, you don't find any wine. All you find is beer. So you buy some beer and come back home. Could you say that these two products are perfectly substitutable, or you were completely happy to buy that beer and have it for consumption? Could you say that beer and wine are like products? I think the majority of you might have said, if we were doing a live session, that no, of course not, they're not like products. But are they imperfectly substitutable? Are they competitive or substitutable products? Can one substitute the other in a condition, in a circumstance when one is not available? Perhaps yes. So there is a higher probability that a higher number of you would say yes to that question than to my first question. So that is the difference. Like product must be perfectly substitutable, but competitive or substitutable product may not be perfectly substitutable. It's a broad concept pretty much. And the next element was so as to afford protection to domestic industry. And the court has defined this element in this paragraph where it says, this is not an issue of intention. If the measure is applied to imported or domestic products so as to afford protection to domestic production, then it does not matter that there may not have been any intention or any desire of the country to engage in protectionism in the minds of the legislators or the regulators who imposed the measure. So you cannot enter the minds of the legislators who made that measure, who came up with that new law. It is very difficult to discern subjective intention, and therefore they look at this element more objectively. How do they look at this element objectively? They try to identify the objective intention behind the measure. They try to identify the objective intention by looking at some factors. Those factors may include the difference in the taxation. So if the difference is quite high, then it is more probable that the measure was imposed with an intention to protect their own industry. The impact of the measure. So if the measure is having a really bad impact on the imported goods and it is not having the same impact on domestic goods, then even that could lead to a probability that there is an intention, objectively speaking. So they compare and they analyze how the law is drafted, how the law is written, the impact the law is having, the difference in the taxation, and how it is applied. So they look at all these factors and try to understand the objective intention behind the measure to answer the element of whether the country is intending to afford protection to their domestic production. And here is an interesting case, very similar to the alcoholic cases we have seen before. So this case was filed against Philippines by US. So in this case, Philippines was imposing a low excise tax, which is a domestic internal tax, to spirits made from certain designated raw materials, while they were imposing a significantly higher internal tax on spirits that were made from raw materials that were not designated. And US filed a complaint. In Philippines, in practice, all domestic alcoholic spirits, alcoholic drinks, such as gin, brandy, rum, vodka, are made using a specific kind of raw material, a specific kind of sweetener called cane sugar. And on the other hand, all the imported spirits, all the imported alcoholic spirits were made using a different kind of sweetener, which was mostly grapes. So, as a result of that, the domestic spirit was paying a low tax, and the imported spirits had to pay a high tax. So, this was a way of discriminating or imposing higher tax indirectly because they were not taxing the product, they were taxing the raw material used to make the product. Okay. And the court said that these two products are like. If you're making spirits or alcoholic beverages with cane sugar or grape sugar, it doesn't matter. They are still alcoholic drinks. Vodka is vodka, whiskey is whiskey, rum is rum, and it really doesn't matter whether you use cane or beet or grape sugar or sweetener to produce that drink, right? So they are considered as like products, and therefore it violates Article 3.2. And the panel also went ahead to say that, okay, even if Philippines, you do not accept our decision that they are like products, and if you don't consider them like, I think you would certainly lose your case, as even if it is not a violation of Article 3.2 first sentence, which requires the products to be like, it is definitely a violation of Article 3.2 second sentence, which does not require the products to be like, which only requires the products to be competitive or substitutable, which they certainly are. Right. So the last legal provision that we are going to study in this session is Article 3.4. So Article 3.4 is a separate legal obligation which you could also invoke to allege violation of WTO laws. It reads as follows: the product of a contracting party imported by the other party shall be accorded treatment no less favorable. So Article 3.2 doesn't talk about any tax or charge. It's not about financial taxes or financial charges. It is about treatment. Then that accorded to like domestic products or like products of national origin. Again, the likeness of products come back, the like product. test comes back. In respect of all laws, regulations, and requirements. All laws, regulations, and requirements affecting the internal sale, offering for sale, purchase, transportation, distribution, or use of the products. In short, if you have a law or a regulation or a requirement which is affecting competition between like imported and like domestic product in a given market, in your market, in a manner that the domestic product or the imported product is being treated less favorably and the domestic product is being treated more favorably, then that would amount to a violation of Article 3.4. Right? So we break it down to a three-tier test into three elements. The first element is the measure at issue must be a law, a regulation, or a requirement. A requirement could be that you need to apply for a separate license if you want to import this good or sell an imported cigarette. If you want to sell domestic cigarettes, you don't need any license. But if you want to sell imported cigarettes, then you need to apply for a special kind of license. So that's a requirement, right? Or you need to dispose of all imported beer bottles in a disposal unit which is 1,000 miles away from the capital of the country. But you can dispose of domestic beer bottles in any disposal unit in any state of the country. That's another requirement, which is discriminatory, which is less favorable for a like imported product, isn't it? We'll look at other examples in a while. The second requirement is likeness of products. The imported and domestic product must be like. And the third requirement is that the imported product is accorded less favorable treatment. Not the same treatment, but less favorable treatment. When is the treatment less favorable? When it changes conditions of competition between countries in a given market. So these are the three elements that you must satisfy if you want to argue violation in Article 3.4. So once again, EU seals is a very interesting case which applied these three elements of Article 3.4. So in this case, once again, the panel confirmed that the first element that you have to satisfy is that the imported and domestic product must be like. The second is that the measure that you are challenging must be a law or a regulation or requirement that affects the competition between the two products in a given market. And third, the measure should amount to less favorable treatment of like imported products. When is a treatment less favorable? When it disturbs the conditions of competition between the two products in a given market. So in this specific case, it's a really interesting case that we are going to look at again when we are doing exceptions. In this specific case, what happens? EU some time ago banned the importation and sale of seal-made products. So seal skin is considered to be quite warm and quite expensive, and it is highly used. The use has declined quite a lot over the years, but it was used quite a lot in making warm clothes, overcoats, jackets, sweaters, so on and so forth. It was heavily used in Europe. So Europe came up with a measure where it banned the import and sale of seal-made goods, mainly products, mainly clothing, like jackets and overcoats, in the European member states. So what they did, because this was a funny measure, they did not simply ban the import and sale of seal-made products. It was a really funny measure. So what they did was that, well, or in other words, the measure said that we are prohibiting the sale of seal-made products which are made from seals that are killed in a cruel manner. But we will allow the sale of seal-made coats and jackets in EU if it comes from Greenland, for example, because seals in Greenland are hunted in a less cruel fashion. So the picture you're looking at now is a picture of a seal being hunted in Greenland. This was allowed to be sold under the measure. What was not allowed to be sold was products made from seals that were killed in inhuman or cruel manner. So the main argument of the EU was that if you kill the seal by putting your tool closer to the seal's head, then it's less cruel to the seal. But if you do it with a distance, then it is more cruel and more painful for the seal. And therefore, we are banning the sale of those products in our country. So I know, I mean, probably this case would have raised many thoughts and many doubts and concerns, but hold on to them. We will come back to all those concerns. We're going to talk about this case for more than half an hour in the class of exceptions. So let's get back to it, okay? In this case, in the EU seals case, basically the court decided that this measure was a violation of Article 3.4. Okay, it was a violation of Article 3.4 because the seal made products coming from seals killed in less cruel way are like seals that are killed in less cruel way. So um, the court said that it doesn't matter how you kill the seal is killed, right? So um, they are like products. Both if you are making a jacket by killing a seal in a less cruel way, it's like a jacket made from killing a seal in a more cruel way. And that is how they decided the case. This is another case very similar to what we have seen before, because in this case, Thailand introduced a new regulation, a new requirement, a domestic requirement, where it required cigarette retailers, so shopkeepers, to apply for a separate license if they wanted to sell imported cigarettes. And they did not need to apply for this additional license if they were only wanting to sell domestic cigarettes. So that caused a lot of hardship and time, investment, and resources for retailers. And therefore, it was in a way discouraging for retailers to sell imported cigarettes because they did not want to invest all the time and finances to apply for the license to be able to sell imported cigarettes. So they preferred selling domestic cigarettes in their shops. So Philippines filed a case against Thailand, arguing that this requirement of separate licensing is a violation of Article 3.4 because imported and domestic cigarettes are like products, and this is a requirement or a law, second element of Article 3.4, and this law amounts to less favorable treatment against or for imported cigarettes. So all the three elements of Article 3.4 are met, and the panel agreed with the arguments given by Philippines, and the panel said yes, it is a violation of Article 3.4 because it creates unequal competitive opportunities and conditions between imported and domestic cigarettes in Thailand. And then you have this another interesting case, Brazil retreat tires. We're going to have a look at this case again when we are doing the exceptions. So I think we can skip this for now. And finally, going back to the first element of Article 3.4, you need the measure to be a law or a regulation or a requirement of any kind, of any form. So it is really broad. What law, regulation, or requirement do you need? Does it need to be a government's action, a requirement, or a law enacted by a government? Or would you also consider a private company's or a private industry's requirement to be sufficient to satisfy the first element of Article 3.4? So the court has over the years said that you need the action to be coming from the government. You need the law or requirement to be coming from the government. However, we will also accept the actions which are coming from the private stakeholders as long as there is a close nexus between the private action and the government action. So, for example, where private industries impose a requirement, but the industry is controlled by the state or controlled by the government. In the case of state-owned enterprises, right? And the likeness of products. So we now have, and the good law and the most updated law to determine likeness of products in the case of Article 1 and Article 3, all the obligations in Article 3 is this. You have four guiding factors that you can see on this slide: physical properties, nature and quality of the products, same or similar end use in a given market, consumer taste and behavior, and tariff classification. You will assess all four guiding factors in context of a given market, in context of a relevant market, to see whether these products are competitive, whether they compete, whether they have any competition between themselves in that given market, not in different markets. And based on weighing and assessing these factors, you would take a systemic decision or a systemic conclusion you will arrive at as to whether products are like or unlike. So these factors, once again, are not the essential elements of likeness of products test. They are merely guiding factors. So you could decide in light of two or three or four or just one. And this is the last case we'll look at in this class, US clove cigarettes case. In this case, Indonesia files a complaint against the US at the WTO with respect to a provision in the US Family Smoking Prevention Tobacco Control Act that banned cigarettes made with clove as a flavor. So Indonesia alleged that the act prohibits the sale of certain imported products, imported cigarettes that contain the flavor of clove. However, it did not prohibit the sale of other cigarettes, flavored cigarettes that contained, for example, the flavor of menthol. So you could continue selling without any problem a flavored cigarette as long as it's flavored with menthol, but you could not do it with clove. And Indonesia filed a case arguing that it's a violation of Article 3.4. It's a requirement. It's less favorable for imported cigarettes because most of the imported cigarettes are made by using clove. And the only question for the court to decide was, are clove cigarettes like menthol cigarettes, right? So are they like products? And they looked at the relative toxicity of the products. They said, okay, they're both toxic. They both have tobacco. They both are flavored. One has clove flavor. The other has menthol flavor. And their additives, their health effect is the same. They're both injurious to health. They're wrapped in the same manner. They're processed. They're manufactured in the same manner. And they're both used by mostly young smokers or smokers that are starting their journey on smoking because it reduces the harshness of tobacco, and therefore it mostly appeals to youth and beginners smokers. So they pretty much have the same end use, they have the same physical characteristics, and the consumer's preferences. So if you're starting to smoke and you want to buy a flavored cigarette to reduce the harshness of tobacco, and you can't find, even if you like the flavor of clove, you can't find clove cigarettes, you will go for menthol cigarettes. So the consumer preferences are not very different or diverse in this respect, and other countries have same tariff regime on different flavored cigarettes. So they applied the test and they said the same end use. They are both to be smoked, satisfying an addiction to nicotine, used for creating a pleasurable experience associated with the aroma of the smoke, and the consumer taste and habits are very similar, because the panel found that for young and potentially young smokers, clove cigarette or menthol cigarette are similar for the purposes of starting to smoke, and therefore they are sufficiently substitutable products, and the tariff classification by other countries is all the same, and therefore they are like products. They are not unlike, but they are like products. And because they are like, US has violated Article 3.4. Right, so now we come to the end of the lecture. I'll ask you the same question again. I've asked you a very similar question before. Is a Samsung smartphone like an Apple smartphone? Think about it. Think about it in light of the four guiding factors: the features, end use, consumers' preferences and behavior, and tariff classification. Are they like? Well, the next question is, are these two products directly competitive or substitutable for the purposes of second sentence of Article 2? If you think they're not like, it might be easier for you to argue the latter than the former, isn't it? So that explains the difference between Article 3.2 second sentence, that does not require the products to be like, but makes it easier for the complainant to prove violation by only arguing that the products are competitive or substitutable, even though they are not like. But Article 3.4 and Article 3.2 first sentence need the products to be like products. Now, this is where I will ask you to, once you finish this lecture, this is the last slide, I will ask you to go back to the class handout. Remember, I asked you to pause and go to a class handout I had uploaded in this week's folder, in today's sessions folder. I will ask you to go back to that handout and once again analyze if all the measures mentioned from point A to J are violating any non-discriminatory provisions of GATT 1994. So I need you to do two things. First, read them and see whether it amounts to discrimination under Article 1 or 3. And second, identify the exact legal provision that it is violating. So you must identify whether that scenario or whether that measure that I've described in the handout is violating Article 1 or 3.2 first sentence or 3.2 second sentence or 3.4. Okay, so these are four legal obligations we have studied, we have discussed in this session, and now is the time to go back to the class handout and identify these legal provisions they are violating. And you will see how your understanding has changed, how it has developed over these 2 hours. I will leave you here, and I really hope you enjoyed this lecture. And please do not forget to do your readings and then your quiz. Until next, goodbye.